Welcome back. This is Nick Morgan with ICAN, Investor Choice Advocates Network, and co-host of today's SEC Roundup. Joining me as always as co-host is Tom Zucchero. Tom, thanks for joining.
Thank you, Nick. Happy to be here.
And we are very pleased to welcome back to SEC Roundup John Deaton. John, thanks for joining.
Thank you for having me. Always a pleasure, guys.
John, of course, heads up his own law firm, will be well known to most people as in the crypto community, representing the voice of the investors. So I really appreciate you coming back. And the last time we spoke, John, we were talking about the Ripple case.
Yeah,
it's been almost a year or so. And needless to say, the world has changed a bit. You've been busy for one thing. You put out a book called Food Stamp Warrior. So congrats on that.
Thank you.
And the crypto world also has seen quite a few changes, including progress, I think, on the front in litigation involving the SEC. So the reason why we're getting together today is to talk about two big hearings that happened in the last few weeks. One in federal court in New York, that was SEC versus Coinbase, and one in DC that happened about a week or so later in federal court again, SEC versus Binance. John, I know you attended the Coinbase hearing, so we're going to get your thoughts on what happened there. They were both kind of remarkable hearings in that there was a lot at stake, and the judge, in both cases, both judges took a very long time to hear argument. But before we hear the details about what you saw at the hearing, Tom, you have filed many motions to dismiss against many SEC complaints. Maybe for people who aren't familiar with that process and in particular a motion to dismiss against the SEC, what's at stake? What are the odds of winning something like that? And just sort of in general, set the table for us, if you would.
Yeah, they're very long odds. The SEC starts those motions on second base, if not third base. And it's really difficult to win a motion to dismiss. Essentially, the court has to accept everything the SEC has alleged as being true, and then determine whether, as a matter of law, they've stated a claim. As for fraudulent intent, also called scienter, all they need to say is defendant had scienter, and that gets them over that hump. This is compared to private cases where in the mid-90s, Congress passed a statute, the Private Securities Litigation Reform Act, which made it much harder in the private context for plaintiffs to defeat motions to dismiss. And in the private securities context, defendants win those motions at least 50% of the time. And that was intentional on Congress's part to make it harder for plaintiffs to get past that burden. But that statute doesn't apply to the SEC and SEC enforcement cases. So the SEC's burden to overcome a motion to dismiss is very low. And it's very difficult to win a motion to dismiss against the SEC. So when one is won, it's quite an accomplishment.
So, John, the SEC comes into court on second base. And so at the Coinbase hearing in New York that you attended, first maybe set the scene. Were there a lot of people there? And what did you think?
Yes, and I agree with everything Tom said, and especially in a fraud case, which I think we have to distinguish the Coinbase and the Binance. I agree. Normally, I would say best chances are 5%. We could debate whether that's high most of the time. I do put the Coinbase one, not that it's 50% or anything that high, but I do put it up significantly higher than your normal one, and we could talk about that. But there were, I sat behind Paul Graywell and his Coinbase team. There were probably 40 to 50 people in the courtroom. One thing I was impressed the most was from Judge Falia. She came in, she had read every brief. She read every amicus brief. She even commented about several of the amicus briefs and the good points that they had made and questioned the SEC. And unlike a lot of hearings where the attorney gets to go and start making their case, she came and said, I'm dispensing with all that. I'm going to spend 2 hours grilling the SEC and then 2 hours grilling Coinbase. And at the end, if you think my questions didn't cover something, let me know. And they were very pointed questions. And I would remind your audience that she wrote the Uniswap motion to dismiss. And she's very familiar. She's probably the most familiar judge on blockchain and crypto in the United States right now. So I was quite impressed with her questions.
That's good insight, John. I understand from others who attended or listened to the Binance hearing, the judge in that case also paid a lot of attention to amicus briefs, which obviously at ICAN, and I know you've been very active in the amicus brief space as well. That suggests that these things do have an impact. Judges read those things.
100%. Keep doing what you're doing at ICAN. I'm telling you, it really does make a difference. Judge Failure at least 4 times said, whether it was the DeFi one or one of the other ones, said, they make an excellent point. How is this? And then, as she was analyzing the Howey case. And so the number one thing that I took away from it really was the SEC is really still struggling with their enforcement actions on crypto. And they really are, very inconsistent. The main argument, I was sitting there thinking, because the SEC attorney said, look, every one of these tokens that we've alleged, the 12 or 14, whatever, Coinbase, they meet the Howey test because they're an investment into this ecosystem where their token holders are expecting a profit. And I was sitting there thinking, everything you just said applies to Bitcoin, like the whole argument. And then the judge asked about Bitcoin, and the response was amazing. The SEC attorney said the reason that Bitcoin is different is because Bitcoin doesn't have an ecosystem.
Wow.
And I almost fell off it was one of those involuntary, I almost went, what? Right? And then I'd have been escorted out of the court. But I almost involuntarily go, what did he just say? It was striking. And so that was probably the biggest takeaway that I had. And the only final comment could be that something that you know about, both of you, the embodiment theory raised its ugly head in And the SEC attorney said, Judge, you got to understand that the token itself's not a security, but the token represents the embodiment of all the promises and inducements the promoters and the issuers made. And so that's something that we had discussed, before. I know you're familiar with theory, that novel theory.
Right. And I understand also in both hearings, because it was in both motions, the major questions doctrine also came up and probably got a frosty reception from both judges. Obviously, it would be a huge thing to say that the SEC can't even act here and requires congressional direction before acting. So I wasn't really surprised that neither judge apparently was super receptive to the major questions doctrine. What do you think about that?
Yeah, you were 100% on point on that. I was maybe a little bit hoping that she would touch it a little bit more, but she basically said that, it's not her role as a district judge to engage. I mean, I think that if I could Monday morning quarterback, which I wouldn't want to do because Coinbase's attorneys were outstanding, would be just to point out that when you take like cross-border payments and you take, the foreign exchange payments, things that crypto could be used for, it does reach to very, trillions of dollars. And so it could meet, but she wasn't having it. So I don't blame them. She sort of gave that frosty message, which, that's for somebody higher than me. But they tried to go down that road, hanging their hat on Gary Gensler's initial testimony that exchanges like Coinbase fell outside the regulatory purview of either the CFTC or Coinbase or SEC. But she wasn't having it. You were right.
Yeah, I think you're right. That's a higher court question. That's a Second Circuit or DC Circuit. Well, thanks for your insights, John. I guess we'll all wait for the rulings. I mean, it would be even a huge win if they got a dismissal with a right to replead. That would be a big deal.
Absolutely.
So maybe the next few weeks or months we'll get those, and we can loop back again and get your insights on that.
Thank God Bitcoin doesn't have an ecosystem.
Yeah, right.
Anyway.
All right. Well, thanks very much, John. Thank you, Tom. And for the rest of you, we'll see you on the next SEC Roundup. Until then, goodbye.